Welcome to our podcast. It's brought to us by the Touro Law Review and the Touro University Jacob D. Fuchsberg Law Center. Our guest today is attorney Lisa Gochman, and she's going to speak with us about her experiences arguing before the United States Supreme Court. And she's put these experiences together for us in a memoir, At the Altar of the Appellate Gods. So we hope that you will read this book, which is available to all. Lisa, welcome.
Thank you, Professor.
And you'll call me Peter.
Thank
And
you, Peter.
we always ask our guests, our panelists, to introduce themselves and tell us a little bit about how they got to this point in their career. And it's a little introduction that we find particularly interesting to students. So please tell us a little bit about yourself and your career.
Okay, I'm going to start back in just before law school, and why I wanted to go to law school, because I find that that's very interesting fodder for discussion as to why people end up in law school. And I was out of college for a year. I was working in a publishing house in New York City, making $8,000, which back in 1981 was very little money. And I knew that that was not going to sustain me for living in New York City. So I wanted to stay in publishing. So I went to law school thinking I was going to go into publishing law or be a literary agent or something along those lines. Went to law school, Cardozo School of Law. I think I was like the 6th or 7th graduating class. And my first summer between first year and second year, I got an internship with the Legal Aid Society Trial Division in Brooklyn. And I was introduced to something that was completely foreign to me. It was not contracts. It was not property law. It was the most fascinating law I had dealt with yet. One of my first assignments was a search and seizure memo, and I was hooked. So that's why I decided to become a criminal lawyer. I love writing. I've always loved to write, and being an appellate lawyer on the prosecutor's side has just suited me well. Since then, after graduation from law school, I went to the Bronx District Attorney's Office and worked in its appellate section for almost 3 years, moved to New Jersey and joined the Attorney General's office in Trenton in the Division of Criminal Justice in its appellate section. I retired from there after 26 years of service in 2012, and since then I've been working for the Monmouth County Prosecutor's Office in Freehold, New Jersey, of counsel in their appellate section. So I've pretty much been an appellate prosecutor my entire career.
All right. I find all that interesting. One thing that's particularly interesting to me, at least as related to your book, is when you talk about ultimately why you were chosen to argue the case. One of the deciding factors seemed to be the quality of your brief. And that when your own office reviewed your brief, they said, ooh, this is pretty sophisticated stuff, well presented, so maybe we should turn to you to argue it. So, but we'll get to that. And so, if we turn to the substance, At the Altar of the Appellate Gods, you have written this memoir, and why did you choose to write this book?
It's not like I was not obsessively thinking about my argument, which was without question the highlight of my career, the highlight of my life, other than maybe the birth of my child and my wedding. And I had put together a PowerPoint presentation that I give to students, to lawyers, and it was a wonderful outline of this book. And one morning in May of 2019, I woke up and I thought to myself, I have to write this book. And that's what I did. And the pandemic hit a few months later. I had nowhere to go, nothing to do. It was a wonderful time to write a book. And it was just, I wanted people to understand the workings of the United States Supreme Court. I wanted people to understand the case, Apprendi versus New Jersey, which was monumental. It was a landmark sentencing case. And I think that appellate work and appellate courts are shrouded in mystery. Nobody really knows what goes on behind the scene. You see a little tiny glimpse of it, maybe on the news. You'll see a sketch artist who has done a picture of an advocate standing before the United States Supreme Court, and that's all you see. And I knew that nobody had written a book like this before. I felt I had a good story to tell. I had an excellent case, and it just came together.
Now, so it sounds to me like you had both motive and opportunity.
Yes.
We express it that way. And I do want to spend plenty of time talking about the dynamics and the insights into appellate argument, but let's give it context. And you did talk about the significance and importance of the case. So, let's put on our due process hats, I guess, for a while. And why don't you give us your perspective on the case before we get into the dynamics of the appellate argument?
The case was based on New Jersey's hate crime statute, which allowed a sentencing judge to make a finding of fact that a defendant acted with a racial motive in determining the final sentence. And the issue became, is that determination a factor for the jury to find? Is it an element of the underlying offense, or is it a traditional sentencing factor that a judge can consider in determining a sentence? So the case arose in South Jersey, in a small rural town, where Charles C. Apprendi Jr., who was a white middle-class pharmacist, decided that a family who had just moved into his neighborhood, and the family was Black, he decided that he didn't want them in the neighborhood. So on 4 separate nights in 1994, just before Christmas, he fired his rifle into the house in the dead of night. On the 4th night, fortunately, no one was hurt, no one was killed. There was significant damage to the home, and of course, the psychological damage to the family was horrendous. Charles Apprendi was arrested, and he admitted to the police that evening that he fired his rifle into the house to send the family a message that they were unwelcome in his neighborhood. The case he was indicted on multiple charges, including weapons offenses. He pleaded guilty to the crime of possession of a weapon for an unlawful purpose. And you talked about motive and opportunity before. The underlying crime for possession of a weapon for an unlawful purpose is, of course, the possession of the weapon. And the unlawful purpose is to harm a person or property. But when Apprendi pleaded guilty, he didn't have to explain why he wanted to damage the property or hurt the people inside the house. All he had to do was say he wanted to scare them. He didn't have to say why he wanted to scare them. That was motive. And ordinarily, prosecutors do not have to prove motive of a crime. Oftentimes, motive is unable to be uncovered. We just don't know why someone committed a crime if there are no witnesses and there's no other indication of intent, not intent to commit the crime, but the underlying, why did he want to do that? So that was left to the sentencing judge to determine. And the issue became that when Apprendi pleaded guilty to a second degree crime, he faced an ordinary term of between 5 and 10 years in prison. With the addition of the hate crime statute, it allowed the judge to increase Apprendi's sentence to that of an ordinary term for a first degree crime, 10 to 20 years. So that became the problem. Is it the jury or the judge that makes the decision that enhances a sentence above the ordinary statutory maximum? And that's the issue that ultimately went to the United States Supreme Court.
So it was then, in that sense, I guess a narrow issue, but incredibly significant for those students who haven't had maybe con law yet, even if you just had torts, you deal with a similar issue. I mean, you could have the intent to punch someone in the nose, and that's really, in torts, that's all you need. The motive, whether you think that's very funny or you don't like them, that doesn't really come into it. All we have to show is that it's your intent. But I guess when you put it into the criminal and constitutional realm, where you're talking about deprivation of liberty, then it really does
Exactly.
a more significant context.
Right. And the case came up under the Sixth Amendment, right to a jury trial. Is it a judge or a jury who makes this determination? And also the 14th Amendment due process of law, which we had argued that Apprendi got his due process of law because we had filed a motion, which was his notice, and he was entitled to a hearing on the extended term, in which he testified. I mean, he testified that the owners of the home, the door had a purple border, and that's what incensed him and why he fired at the house on 4 separate nights. So we had argued that he did get his notice and due process of law, his opportunity to be heard. But the real issue was the Sixth Amendment issue as to, is it a jury or a judge who makes that determination that increases a defendant's sentence above the ordinary term? And the case took on much broader issue than that. Well, we were arguing simply for the hate crime statute that it was constitutional because motive has always been a traditional sentencing factor that a judge can find. The problem is that there are a lot of federal statutes at the time that allowed the government to present to a jury the underlying crime. Let's say possession of drugs. All of the federal prosecutors had to prove was that the defendant was in possession of drugs. It was then left to the judge to determine the quantity of the drug and the type of the drug. And depending on the type of the drug and the quantity of the drug, the defendant's sentence would increase. So those statutes were also in peril based on Apprendi versus New Jersey, which is why the Solicitor General's office got involved in my case.
And because they want to defend the constitutionality of those statutes,
right,
could be affected by that. All right. Well,
correct.
I mean, obviously this is sophisticated, but it certainly gives us a context. And you said, okay, we argued. So I take it now that's, you were the primary appellate lawyer, but obviously it doesn't start with the Supreme Court. So I gather you shepherded this all the way up through New Jersey and then ultimately to the Supreme Court. So could you, I know that's extremely broad kind of question that I'm asking you, but you just wouldn't mind sharing some of your experiences or thoughts or whatever you'd like with respect to that process of getting the case to the Supreme Court.
Sure. Well, the case was handled in the trial division by the prosecutor in Cumberland County, New Jersey. And at that point, Apprendi pleaded guilty to possession of a weapon for an unlawful purpose. The prosecutor filed the motion for the extended term sentencing under the hate crime statute. The judge found that the hate crime statute applied and sentenced the defendant to 12 years, which was 2 years above the ordinary maximum for a second-degree crime. At that point, while I was working in the Division of Criminal Justice in Trenton, our office handled, I'm going to say about 90 to 95% of all appeals, criminal appeals statewide. And I was not the most senior attorney there, but I wasn't a junior attorney either. I was somewhere in the middle. And the case was assigned to me. I mean, one of the things that I adore about working for a prosecutor's office is I don't have to network. I don't have to drum up business. Cases just come to me. I get my assignments. I do them. And I like that. And this case was assigned to me. The transcripts were about 3 inches thick at the most. There was the plea transcript, the hearing transcript, and the sentencing transcript.
If I let you interrupt for a second, 3 inches is a little or a lot?
Oh, that's very little. That is very little.
Okay. All right.
A murder case can take up multiple boxes
Okay.
of transcripts and motions and other paperwork. This case was one of the smallest transcripts I have had to deal with.
Okay.
And that's when the case was assigned to me. And I sometimes wonder if my supervisors would have assigned it to me had they known it was going to go to the US Supreme Court, but I've never asked them because I don't want to know the answer to that question. But I briefed the case, which means, in trial court, you argue before a judge and a jury. In appellate work, you're basically researching and writing. The defendant files a brief explaining why he believes his trial was unfair or his sentence was too long. And my job is to rebut that in a written brief. And then we have argument before an appellate panel. In New Jersey, it's either 2 or 3 judges. We had 3 judges on this panel. And we argue our respective positions. Defendant's attorney goes first, and then I respond. We wait a few months, and an opinion comes out. And in this case, 2 of the judges found that the hate crime statute was constitutional, that it was perfectly okay for a judge and not the jury to make the finding of racial animosity that increased Apprendi's sentence above the statutory maximum for a second-degree crime. But there was a dissent. And when there's a dissent in New Jersey, meaning one of the 3 judges did not agree and found that the statute was unconstitutional, there's no precedent from a dissent. In other words, you can't say the statute's unconstitutional because Judge Barbara Wecker just said that it was. But in New Jersey, that means it automatically goes up to the New Jersey Supreme Court. We didn't have to, well, defense counsel didn't have to file a petition asking for the court to review. It automatically went up there. And because it was my case, it was still my case in the New Jersey Supreme Court. And we argued there pretty much the same issues, the same, just a different court to argue in front of.
Now, if I may interrupt again, excuse me, but when you say we argued, I mean, it was your case. You did.
Yes.
So
I argued.
I mean, you're being gracious, but it was, so you were the appellate lawyer at the mid-level appellate court, and you were the appellate lawyer before the Supreme Court. And
Yes.
did you write the brief literally by yourself?
Yes.
So
yes, I wrote the brief by myself, argued by myself.
So it was everything. Did you have any conversation with the office before the Supreme Court argument in New Jersey?
Oh, yes.
That was going to the High Court of New Jersey, at least.
Right. At least in my office, all Supreme Court briefs are reviewed by our supervisors, by the chief of the section. And then we had a moot court,
Okay.
which we have before all New Jersey Supreme Court arguments, where attorneys from my office, prepare, they read all the briefs and they ask questions of me or whoever's going to be arguing a case in the Supreme Court, trying to flesh out the issues, trying to give the attorney a better perspective of what to expect when you're actually standing before the Supreme Court of New Jersey.
So long live moot court. I mean, it's a part of law school, and in, I suppose, many offices, it's a part of preparation, especially when you're going up to the highest court in the state.
Absolutely.
So how
Absolutely.
did that feel? I mean, especially when you made the jump from the middle level court to the Supreme Court of the state. I mean, did that engender a certain, I don't know, anxiety, pride, extra effort? How did you feel about that?
Well, I've always loved arguing in the New Jersey Supreme Court. And I always felt that that was, the bonus of my job was to get a case up to the New Jersey Supreme Court. I mean, the problem, of course, is you could lose and you can make terrible law, and that has happened. I don't say terrible law, that the law itself is bad. It's just not pro-prosecution. It may be more pro-defense. And as a prosecutor, you want the law to be in the prosecutor's favor. So, I mean, what was interesting about this particular case, there were 2 things, actually. First, that while I was doing the research and writing in the Supreme Court of New Jersey, there were two cases that came down from the United States Supreme Court on this issue of sentencing factor versus element of the offense. What does a judge have to find? What does a jury have to find? And that's pretty unusual to have two United States Supreme Court cases come down while, on your issue, while the issue is pending in the highest state court. I had a second thing I wanted to say, and that went out my head. And that happens. That happened to me in the United States Supreme Court. Unfortunately, Justice Scalia interrupted my answer before I could give him the second of my responses, because I just frankly couldn't remember what it was. And it happens.
Well, that's happened to me too. As a professor, I actually argued a case before the Supreme Court of California, the tort case. And one thing I learned is to be very careful when you say, I have three things to say.
Yes.
I've sort of gone to several things just in case I forget one. I don't want to be stuck on that number. So
that is wise counsel.
I mean, if it occurs to you, just interject.
Okay.
All right. So you shepherd it through. You get to the Supreme Court. At some point, you get a decision, and
well, we won. And the New Jersey Supreme Court found that the hate crime statute was constitutional and that Apprendi's sentence of 12 years was appropriate under the statute. But I had an inkling that this case was going to go to the United States Supreme Court. And when the justice of the New Jersey Supreme Court, who wrote the majority opinion, Daniel O'Hearn, he wrote in it that the final decision would have to be left to the United States Supreme Court to answer this particular issue, because the federal sentencing guidelines at the time were similar to New Jersey's hate crime statute in that it allowed a judge to make a finding of fact that a crime was racially motivated, and therefore an increased or enhanced sentence was appropriate. So when Charles Apprendi's attorney filed his petition for certiorari to the United States Supreme Court, and for those who are unfamiliar, you can't just go to the United States Supreme Court. You can't just say, oh, I want the court to listen to my issue. You have to file what's called a petition of certiorari, which is just a fancy name for saying, please review this decision from the state court. And I kind of knew in my appellate bones that this case was destined to go up to the United States Supreme Court. It was clean procedurally, meaning there were no procedural issues preventing the court from looking at this case. It raised an important issue of federal constitutional law, and the Supreme Court could only hear issues of constitutional law from the federal Constitution. They can't review cases dealing with state constitutional issues or just state evidentiary issues. It has to be a federal constitutional issue. And here we had the Sixth Amendment and the 14th Amendment. And again, we had two cases that had come down within 18 months prior to the petition being filed that addressed this sentencing versus elements of the offense. But the problem that the Supreme Court had, and they talk about in one of those two cases, Jones versus United States, is that federal statutes are enacted by Congress, and Congress is a co-equal branch of the Supreme Court. So the Supreme Court of the United States is very loath to strike down as unconstitutional statutes enacted by a co-equal branch. But they don't have that same limitation looking at statutes enacted by state legislatures. So I knew that Apprendi was pretty much the perfect vehicle for the Supreme Court of the United States to take up this contentious issue of what is an element of the offense and what is a sentencing factor. So I filed my response, and outwardly I hoped that the court wouldn't take it because I had won in the New Jersey courts. I certainly didn't want the United States Supreme Court to have the opportunity to strike down this statute, this New Jersey statute. But I really wanted to go to the United States Supreme Court, and I really thought that this case could do that for me, and it did.
Talk about a personal, sort of an interpersonal conflict here. You need to win the case, because that's your job and you want to be very good at that. But there's certainly a silver lining to losing, which is you get before the U.S. Supreme Court on the cert petition. So cert gets granted, and here's where your book really, really is focused and compelling. Not that it isn't elsewhere, but here's what people I think really want to know about. So cert gets granted, and then a couple things have to happen. First, your office has to decide who's going to argue before the Supreme Court, certainly a plum in any office. And that's what I found so interesting. I tipped the hand a little by saying, certainly your brief helped give you the credibility to argue it. But if you wouldn't mind talking about your feelings and your insights as your office made the decision, and then it's you, and you have X amount of time to get ready for the Supreme Court.
Well, I had hoped that it would be me. It's one of those be careful what you wish for, though. But I really wanted to argue the case. I knew this case inside and out, but I was too low down on the organizational chart to, just take it for myself and say, no, I'm doing this.
Mm-hmm.
So it was reviewed by the Attorney General of New Jersey, John Farmer Jr., who since went on to be the chief counsel for the 9/11 Commission. He was then dean of Rutgers Law School, Newark, and is now the director of the Eagleton Institute for Politics at Rutgers. And he called me up to his office one Friday afternoon. It still hadn't been decided who was going to argue the case. This was in January, and the argument was already scheduled for the end of March. And he said to me, Lisa, real nice guy, one of the nicest people I have ever met. And he said, Lisa, I really hate taking a case away from a line attorney. He said, but this is my only opportunity to argue in the U.S. Supreme Court. And he was very gracious. And he said I could second seat him, which meant I could sit at counsel table with him during the argument. And I thought that was a decent compromise because I wouldn't have the angst and the pressure of arguing it myself. So I said, okay, what can I do? I mean, he is the chief law enforcement officer for the state of New Jersey. It's his name on the brief as a representative of the state of New Jersey. I was merely counsel of record. And I gave him a copy of my brief, a draft of the brief. It had not yet been filed. And the next week, he called me back to his office and he said, Lisa, I read the brief. These issues are way too complicated. Not that he couldn't handle it intellectually, he just didn't have the time. I mean, he was the Attorney General of New Jersey. He had many responsibilities. And he said, you are the best equipped to do this, so you argue the case. So it was wonderful because I got to leapfrog all the attorneys who had a lot more seniority than me and could possibly say, listen, I'd really like to argue this case. So he told me I could do it, and I got to do it. And again, it was one of those be careful what you wish for, because it was, wait a minute, now I have to do this. But I had one of the best days. I had a great oral argument. I really enjoyed it. I walked away with my dignity intact, which is really what you want to have when you argue a case in the U.S. Supreme Court.
So let's get to that. So you've got, I guess, maybe 2.5 months by the time it's going to, you have part of January, I guess, through March to get ready. You mentioned the anxiety and everything else. So the next part of the timeline sort of is you're going to argue this and you have X weeks to prepare. So if you just give us a little insight into, the mechanics of the preparation and also your personal feelings as you got right up to the may it please the court.
I was really busy during that time. I mean, I didn't have just this case on my desk. I had other New Jersey Supreme Court cases. In fact, the date that I filed my Supreme Court brief, which is right behind me in that shadow box, at the time it was being filed by the printer down in Washington, D.C., I was in the New Jersey Supreme Court arguing an unrelated case. And I had other cases that I was arguing up until the time I went to Washington. So I prepared the best that I could. I approached it like I would any other case. I knew it was qualitatively different, but I couldn't, really psych myself out about it, because then, I mean, there were moments when I felt, why am I doing this? I can't do this. This is not, I don't have an Ivy League education. I didn't clerk for a Supreme Court judge. How am I going to argue before the United States Supreme Court? But for the most part, I didn't have time to think about that stuff. I had a child I was raising. I mean, my husband took on lots of the responsibilities at home, but I was still working a full-time job. So I had to approach it like I would any other arguments. Of course, I had to buy a new suit, and I had to buy a new briefcase, and there were all those other, thing I had. And I was the only person assigned to write the brief. And I had to make my own travel
Mhm.
arrangements. I had to arrange for all of my work to be sent down to Washington, D.C. in advance, so I didn't have to drag everything with me onto the train. So I didn't really have time to think about the bigger picture in terms of, oh my God, the existential crisis stuff. I didn't have time to really think about that very
Yeah.
much. But it didn't, I mean, I never lost sight of the fact that I was going to be arguing in the United States Supreme Court, which is really this appellate lawyer's dream come true.
Mhm. Okay, so it's what they say about the Super Bowl, just prepare as if it's any other game, but you sure know it isn't. But it sounds
Right,
like you did follow that strategy, and maybe it helped keep certain anxieties, et cetera, in check. It's not going to eliminate them, but keep them.
right.
And then the day arrives. Uh, I mean, walking into the court, and that had I can't imagine how that felt. But there you are, and you're about to start. Things start. So again, a very broad question. I invite you to tell us anything about that day, uh, right before the argument begins or during the argument. I was certainly struck in the book when you talk about 80 plus questions asked of your opponent and 50 plus asked of you, and even the justices telling one another to chill a little bit, let the attorneys answer. So now I give you the floor to talk about as the argument begins and as you walk in and all the way through the, what was it, 45 minutes for you, or how long did you have?
Well, each side gets half an hour, but I had to split my time with the Solicitor General's office. They came in as
Okay.
amicus. So I got 20 minutes and they got 10 minutes.
All
But
right.
I knew going in that regardless of how long I had, I needed to be prepared for anything they threw my way.
All right. So you have the floor. Go ahead.
Okay, walking into the courthouse, I mean, I really wanted to take it all in. I knew that this was a momentous occasion for me, and so I did. And my memory of that day is really pretty sharp, because it really was just such an such an experience that I never imagined myself being there. But I wasn't nervous. I was excited. I was taking it all in, and I really enjoyed it. I think the thing that threw me a little was how close litigants stand near the justices when you argue. When you're in New Jersey, the tables for the attorneys are much further back from the bench where the judges are. Here, if I was looking at Justice Ginsburg, Ruth Bader Ginsburg, who at that time was sitting on my far left. The justices sit on the bench in order of seniority. So as a new justice comes on, everybody switches seats. So Justice Ginsburg was on my far left, Justice Breyer was on my far right. If I was addressing Justice Ginsburg, I could not see Justice
Mhm.
Breyer in my peripheral vision. That's how close I was standing. And in a way that was better, because it blocked out everything else behind me. And that's one of my issues as an attorney. I hate public speaking. I hate standing in front of an audience. So I can talk to judges. but if I have to turn around and talk to everybody in the room behind me, that's very nerve-wracking for me. But I was just in my lawyer zone. I can't explain it other than that. I knew when my adversary, he argued first because he was the petitioner and he has the burden of to to argue to the judges that the statute was unconstitutional, and get them to overrule the Supreme Court of New Jersey. So as I was listening to the questions that were posed to my adversary, I started relaxing because I knew the answers to those questions. I got up there and the animosity that was directed towards my adversary now was squarely directed at me, and it was a very hot bench. I was interrupted more than I was able to finish a sentence. I had one moment of reprieve when Justice O'Connor asked me about sentencing law, back when she was a sentencing judge in Arizona. And I knew based on those two cases prior to my argument that had been decided by the United States Supreme Court on the element versus sentencing factor, I knew that I had Justice O'Connor on my side. And I remember as she was speaking to me, and sometimes justices will ask a question of counsel, not to trip them up, but just to telegraph to their fellow justices what they're thinking. And I knew that this was one of those questions, that she wanted to tell the other justices why the hate crime statute was constitutional. And I remember thinking, as she was talking to me, this is so cool. Justice O'Connor is asking me a question. Because I was a first-year law student when she was appointed by President Ronald Reagan to be the first female Supreme Court Associate Justice. And that was a momentous occasion for women lawyers. And like I said, I had just started law school. So she was always an idol of mine. So for her to be asking me a question was really very cool.
And she's on your side.
Yes, and she was on my
she's on your
side.
side. So
Yeah,
there you go.
yeah.
All right. So go ahead. If you'd like to just continue to share the insights, etc.
I felt that I held my own, which again, as I said before, I walked out with my dignity intact. And when we did walk out, when it was over, because what happens is you don't really know how much time you have. You're not supposed to look at your watch. You're not supposed to look at this analog clock that is high above the justice's head. Your only temporal clue, and again, I only had 20 minutes, is a little white light that lights up at the podium when you have 5 minutes left. And then when the red light lights up, you finish your sentence and you sit down. And I remember sitting down and just going like, oh my goodness. And Ed Dumont, who is the Solicitor General, the Assistant Solicitor General who came in as amicus, got up and he started speaking. And I thought to myself, I better start paying attention. This argument is still going on. But I was lost in a post-argument stupor for a few seconds. And while Ed was arguing, and I was really glad that Ed was there because he was a seasoned advocate. He had argued, I think, 12 cases before the the United States Supreme Court at that point. And I was an unknown. I mean, I felt like I could argue this case, but what if I got up there and I couldn't? What if I got up there and I was so overwhelmed by the situation or couldn't answer a question? So I was glad that he was there because I knew he could pick up the pieces if I had made a mess of everything. But I didn't, but he still argued. And the most amazing thing was that Justice Thomas asked him a question. And at that time, that was the first question that Clarence Thomas asked in 10 years. So that was another, interesting moment in Supreme Court history, was actually getting to hear Clarence Thomas's voice during my argument. And then when it was done, we were all shuffled out a side door. And I couldn't believe I had argued a case in the United States Supreme Court and lived to tell the tale.
Yeah. Well, I'll share one brief story, and then I want to ask you for some final insights. I was arguing a tort case before the Supreme Court of California. There were 9 cases consolidated, and there were 2 attorneys picked. So there were like 18 attorneys vying. I'm a New York lawyer. The court admitted, I wrote a kind of a friend of the court brief. And so they admitted me pro hoc vici, and I was chosen as one of the 2 lawyers. So there were 17, 16 California lawyers really angry at me. Okay. So there were 2 lawyers on the same side, each had 45 minutes. The first lawyer struggled, and the court was so frustrated with him. Then I went second, and I got interrupted at May.
Wow.
I said May, and they interrupted me. They're kind of frustrated with the other lawyer. They were hoping that, I guess, as a professor, I get cut a little slack, frankly, which you didn't. As an advocate, I'm sure they don't get cut too much slack. But that was interesting for me. So what message, if you will, or what insight or sort of final takeaway, especially as things have percolated over the years for you? I mean, you have a great book here that has a lot of this, but what sort of ultimate message or insights would you like to share with us?
I've thought about this a lot, and really, it's a question of rising to the occasion. It's a question of taking what is given you and running with it. And, I'm not a double Ivy. I'm not a single Ivy. I went to I think my law school has a bit more national prominence due to, the Innocence Project that was started by Barry Scheck. But when I was in law school, Barry Scheck ran the criminal law clinic. I was in that. That was before DNA took off as a means of identifying criminals or using it in a forensic sense. So, here I was from a law school that didn't really have any national fame. A decent college, University of Rochester was wonderful. And I got to argue in the United States Supreme Court. And I didn't know anyone. I didn't have any ins or connections. And I think the takeaway is that you can rise to the occasion. You can do whatever is required of you, even if you don't necessarily have that background. And don't be afraid to take on these assignments and these cases and just go where they take you. And I mean, going to the US Supreme Court also takes a tremendous amount of luck. There are 75,000 petitions that are, I don't think it's that many, 700. The court only takes about 1% of all the petitions that are filed in a given term. So a lot of it is luck, but a lot of it is also just recognizing, what's important, and following your heart. And I know a lot of law students are going to be listening to this. Follow your passion in the law, because otherwise you're going to be bored to tears for the rest of your life. I did criminal law my entire life, and I've loved every minute of it. And I know attorneys who chose other careers who, maybe it wasn't quite the right fit. So follow your passions, rise to the occasion, and just do your best.
All right. Well, I certainly want to thank you for that final message, but also for all the insights that you shared with us. Our guest has been attorney Lisa Gochman, and she has been talking about her experiences before the Supreme Court of the United States, which you can, and I urge you to read about her book, At the Altar of the Appellate Gods. It's her memoir. So once again, Lisa, thank you very much for sharing this.
Shameless plug. Shameless plug.
We'll get a double screenshot of the book, and it comes highly recommended. So
thank you.
And thank you. I've been your moderator, Professor Peter Zablotsky, and that brings us to the end of our podcast. Thank you very much, Lisa.
Thank you, Peter.